Enjoy your vacation in Delhi.
I'm sorry.
You can enjoy your vacation in Delhi.
Yes, who's next? Yes.
Petitioner. The Lord, as a Lordship rightly put it, there is a practical difficulty from courts that the law is valid for a particular amount of time and then it's declared invalid. And courts in England, courts in India are all grappled with the question what happens to that declaration of the law. Now, the difficulty arises where the judgment is silent on its operation. If the judgment says that this will operate, it will not affect past acts, it's all right. But the judgment doesn't say so, then what happened? That is a major problem. Number one, the point arises because of the use of the word void in 13.2. That's how the problem starts. And if your Lordship sees 31 and 32, I'll just give a broad outline of what I'm going to say, but I'll come to you with the points. When the draft legislation was being made, they said that insofar as pre-constitutional laws are concerned, to the extent they will be inconsistent with party, the law shall stand abrogated. The word used was abrogated. That's furtherly consistent in basic capacity and abrogated. But insofar as post-constitutional law is concerned, they use the word to the extent of inconsistency, it will be void. Ultimately, in the meeting of 8th October 1947, when the final draft was made, 31 and 32 both use the word void. Now, the legal jurists, Sir William Wade and English courts have held that the word void and void are voidable, are imprecise terms. And the difficulty in using the word void in a public law statute is that we mentally try to bring a concept of contract law into the concept of void ab initio, and so on. However, the difficulty arises because the judgments are given. When the Lordship declares 6A to be invalid, what is the impact of the judgment? Does it mean that 6A was never valid from the day it was enacted? Does it mean it was invalid from the date of the declaration? Or is it possible to have a wide idea where the courts have now introduced the concept of the second actor, theory of the second actor, where by a declaration, the law is invalid. I will come to obliteration later. The law is invalid. It is invalid in law, but it exists in fact. So there are articles which I have set out and well recognized articles saying that this is the metaphysics of validity. In law, there is invalidity. The law is not there at all. But in fact, it was there. Now, how do you solve this particular problem is the main question. And there is one judgment of the English court which recognizes this problem. They say for England it doesn't arise, but for countries having written constitution, this should be a practical problem which the courts in that country must resolve. That's the problem. Now, what has happened is this. The question referred to is in the context of Article 20, in the context of immunity. Now, I will submit two basic questions that arise. If your Lordship holds that the protection of the 6A was in the nature of an immunity, was in the nature of a protection, then will your Lordship read that protection into Article 20? I would further go to say that 20 should not be read in isolation. 20 should be read with 21. These articles go together. So, reading 20 and 21 together, 6A is an immunity, and the Lordship rightly pointed out. 6A did not come in 2004. From 1969, we had the single directive where you could not proceed against people above joint secretary records for prior approval. That was literally valid but invalid by being on the ground. You can't do it by a directive. There is no statutory provision. How can you do this by a directive? Then they introduced an ordinance. Then they introduced the act. Lordship will see from 1969 to now, last 55 years, except one period of 18 months, this protection always continued. This protection always continued, and I have put it in my name. Now, when this immunity is taken away, will Subramanian Swamy then say that from 2004, if it is invalid, if it is obliterated, quote unquote, the law never existed? What happens to all those cases where sanction was granted, not granted, etc.? That is the problem that Lordship is. So there are two parts to it. One is the Lordship holds that 20 21 grants an immunity. and that immunity cannot be taken away retrospectively. If that retrospectively, if that protection could not have been taken away retrospectively by the legislature, can we interpret the judgment to take away that immunity retrospectively? That's from the context of 20. And then the larger question, if the Lordship wants to answer it, I leave your Lordship. I am going to request the Lordship to hold my humble submission that whenever the court declares a statute to be unconstitutional, it is my humble request that the Lordship, based on the law, that the court declaring the law to be invalid, maybe the High Court, maybe the Supreme Court, could also point out what will be the effect of its judgment. Because there are so many cases where the whole thing is completely unknown. I'll just give an example. In Tamil Nadu, if your property rent was more than 400 rupees, rent tax protection did not apply. You have to go for a civil suit. That law came in 1960, section 10(3)(3). In 1986, the Supreme Court struck it down saying that how does it make a difference? Every tenant is entitled to protection, violative articles. Now, the rent act of 1960 struck down in 86. If a lordship is obliterated, never been accepted, what happens from 1960 to 86? Take a criminal law, Mitchell's case. Did not the IPC said if you are a right convict and you commit, then death sentence is mandatory. Honorable Supreme Court held that this is completely unconstitutional. You can't say that the person serving life imprisonment is a separate class and therefore deserves no mercy at all. That was struck down. Now, 302 was there in 1860, IPC. Struck down in 1983. What happens? So, my lord, this is called rightly mentioned. There could be different considerations in a taxing statute, different considerations in a welfare statute, different considerations in a criminal statute. So the point they are making is, wherever the law is intended to protect, preserve fundamental rights, if there is some taking away of that right, it is challenged. And if a lordship then strikes it down, as the general rule, the liberty should go from the beginning is my humble submission. But if it is creating some impediments, and it is retrospective, that also should get retrospective. But if I am getting some protection, say for example, suppose there is a law which says that if unless your income is more than 3 lakhs, you should not be punished. Suppose the court strikes it down, then I would say it is prospective because all along people, smaller SSCs will not be prosecuted. That is the law. So, your Lordship permission, shall I take 23 first and when you go further? Yes.
Whatever you want.
Yes. Lordship, read first.
That's why I had mentioned that or also that while interpreting, we'll have to see what is the consequence of a protective law which has been struck down. It will be different from a prosecuting law which is in struck down.
Yes.
One. Number two, if a protective law is struck down, some consequences may arise and you feel that the consequences should normally be enunciated by the court while striking down the law. Worth examining. The second aspect is also that why it was struck down. In this case, and honestly it's troubled me, it's struck down because it is discriminatory intent. So violative of Part 3 as brother wrote. But that discrimination is removed by bringing in a new law into force. The legislature also in its wisdom thinks that protection should be there. But since it granted protection to only a particular class of people, it says now we'll widen the protection, remove the discrimination, and go it beyond even to the retired people. So, when that law comes into force, it will have application from that date of the law. So, people who may be falling in any of the categories will get protection. Now, there is a hiatus period, you say that was 18 months or 2 years or whatever it is, then till the law was enacted and it was struck down as how should the court read it?
Correct.
This is why I'm posing it is because I think you can you should endeavor to answer this conundrum and see and assist us. How should an interpretation like this take place?
In fact, I think I think because every time the judgment is struck down, then what happens? And I'll also deal with this question of obliteration. In fact, when I was talking to Mr. Desai before he was saying that this kind of protection to civil servants is there from the beginning. It's not that it has come with a single directive. The IPC had the provisions of sanction, criminal procedure code that sanction for very good. Idea is the public servant should not be harassed. If it's a thing, he should not be subject to direct police inquiry. Some filtration mechanism should be there.
Also, were we to agree with you, how should it be done? What is this?
Yes, I will give you. I've written a lot of research on this.
It's difficult per se to say. This is why I put Mr. Difficult to per se that if a provision is cut down, it will not apply retrospectively is very difficult to accept. It will apply prospectively if it is said so. Otherwise, it will apply, the law will be obliterated. MFSI is subject to it. But there are, as you said, there are different nuances. What happens when a protective law, that too on a criminal side, is removed? And removed why? Because it is discriminatory. This is what it is discriminatory, and that discrimination is removed. To some extent, it is academic in character because it's possibly arising only how many cases of those kind are pending now, which were within that window of time between the protection being granted. In that sense, government is not really too much
But they
concerned.
didn't give an affidavit. But what I thought is the Lordship decided on the constitutional question. And it goes back to the regular bench, then not that bench to deal with that issue. Because they gave an affidavit that in this period there are 197 cases, in 110 we gave sanction, we didn't give sanction, etc. And the court wanted that particular bench, it came first before the two judge bench before they reported it. They didn't have. And Lordship is one very subtle point, Lordship can ignore. What happened when the Lordship declared a statute to be unconstitutional? My humble submission is that the law is not taken away from the statute because what the scholars have said is removing a statute once enacted is a function of the legislature. That can be done only by the repeal. But you will see, you normally repeal a statute, you omit a section. Suppose the main act continues and you omit certain provisions, then there is a omission of that section or repeal of that particular section. When the whole statute is repealed, we use the word repeal. What the courts have said is the court really says this section, this statutory provision is ultra vires part 3. It need not be part 3. Today it can be a violative of 265. It can be 280.
Declaration of law. That's right.
It's constitutional limitations. They need constitutional limitations. And the further difficulty, as my friend also pointed out, your lordships for the last 3 years, we just don't have express fundamental rights. We have got derivative rights now. So many rights have been written to 21. My lord, judgment privacy, various privacy, not such as privacy. So we also have got derivative rights. Now,
And we've also said that these rights evolve.
Evolve.
We can't today specify what
Yes,
it is
yes,
because
yes. So I want to see the article 20. I'm going to make some submissions because I'm saying, please see article 30. It says the extent of contravention, it is wide. Now, what is the meaning of the extent of contravention? Lawrence writes in his book, he says the constitution can be taken to 2 ways. It is self-operative. The law is violating Article 14 is what I am issue. Now, it could be egregiously wide. Suppose we tomorrow say that any person below the height of 6 feet can't apply to the police, you strike it down. It's egregiously bad. But suppose it's a law which requires interpretation, which requires consideration. Now, 6 years asked the question, why was it struck down? The referral order said, referral order didn't talk of classification. Referral order said, can we strike down a law on the ground of arbitrariness? That was a reference to the judgment in many states. The referral order which Subramanian Swamy was there was only on the ground that the arbitrariness can be a ground for striking down the law. But ultimately, the bench struck it down on classification.
on discrimination.
Yes.
Discrimination.
The provided bench can strike on a different ground. There's nothing wrong with that. So that's how it actually went off. Because in the arbitrariness was answered in Shire among the face in a different situation altogether. So please see Article 30. Let's start with Article 30. Major only I show my written submissions.
News.
Yes.
Yes, Mr. Datta has written something.
He began well by saying that I will start constant. He said, very good, or on one point. If you the council, the occasion, it could be more difficult to know if this stops.
Yes.
Yes, but although the only one question has been referred, I have submitted the corollary question that we allowed to argue that determination, because I think now that with this a lot of clarity is required on the point. What is the effect of declaring a particular judgment as unconstitutional? So this is
That in any case, in some way will arise from it.
yes,
There's a, what you are saying is a consequence.
yes,
We are also looking, when we look at prospective, retrospective, the consequence will have to be looked into.
yes. And I think if you're actually want to agree more expand it, there is another side angle. What is retrospective? What is retroactive? We want to clarify that point also later, because something is retrospective, something is retroactive. There is a lot of in fact, there is a judgment which says what is retrospective, what is retroactive. Our Supreme Court also use it in a mixed sense. So in case you're not ready, that will be later. But I ordered it, so it's not this first question or seen. Please come to para 1.3. It is submitted that three corollary questions. Corollary questions also arise for consideration. Whether a declaration of law is violative of Article 14 of Article rights is void and issue under Article 22. What is the effect of such a judgment on action taken or omitted to be taken during the period when the law remained in operation? And whether there is a difference between a law held unconstitutional for lack of legislative competence and a law held to be unconstitutional for violation of Part 3 or other constitutional limitations. Now, I'm going to go to 21. Now, what you can see, 21 reads as follows. No, I'll actually argument on 20, then I'll come to 14 and 13. 21. No person shall be convicted of any offence except for a violation of the law enforced at the time of commission of the offence, charge as an offence. Or she will just mark the thing there. I'm saying that 20 is in two parts. One is no person shall be convicted, and second part, not be subjected to a penalty greater than that which might have been inflicted under the law enforced at the time of conviction of the offence. So my humble submission is 21 can be read basically in two parts. The first part is the pre-punishment stage of the trial stage leading up to conviction. And the second part is post-conviction, that is, what is the punishment inflicted, which can only arise if a person is found guilty. Now, when I read the judgment of Justice Mathur on Transaction Corporation when it was in, his lordship said that 20 grants immunity from ex post facto laws. We traditionally understand ex post facto laws to mean that you can't increase the punishment. If the punishment was 6 months, it can't become 1 year. But is that the limited scope of 20? Does 20 go beyond that? Is the question put by the Honorable Supreme Court, which was referred. And my submission is, though conviction means conviction of an offence, if you lordship see the marginal note of Article 20, which I didn't reproduce here, it says protection of 20, marginal note says protection in respect of conviction of offences. Protection in respect of offence of conviction. Now, can we say that the word protection in respect of conviction will mean not only the conviction should be as per the law enforced at that, but the first part of 20 in bracket 1, clause 1, will include all the procedural safeguards that are available to an accused at that point of time. And I am supported by Justice Matthew's judgment, which says that 21 should also be taken into consideration for that particular purpose. Now, so my first submission is the first part of 20, clause 1, at the pre-conviction stage, will also include all procedural safeguards, procedural safeguards. If that can't be taken away retrospectively, then even the judgment should not be interpreted taken away retrospectively. I'll just read my note and I'll come to those two judgments. The clause consists in two parts: prior of pre-conviction or post-conviction. The conviction of an accused can take place only by following the prescribed procedures starting from inquiry, investigation, trial, etc. If the first stages are not permitted, unless there is a specified prior rule, there is immunity from prosecution and there can be no conviction either. This immunity is entitled to protection under Article 20 in bracket 1. The marginal note refers to protection in respect of conviction. The words in respect of must be interpreted to grant protection to all existing procedural safeguards at the time the offence was alleged to be committed. See so and so. 6A thus creates an immunity or grants a protection and cannot be taken away retrospectively, either by a retrospective amendment or by a judgment declaring such immunity invalid. It would be paradoxical to interpret 21 so as to create an environment on a statutory provision, statutory retrospective provision, but permitting such deprivation by a judicial order. Not so we just put statutory provision.
Mr. Nath, 1 minute, please. Just come to the section 21.
Article 21.
Just read it slowly, the first portion, not the second portion. You're not concerned with the second portion.
Yeah, Lord's will. No person shall be convicted of any offence except for violation of law and force.
Just stop here. No person will be convicted for any offence except for violation of law and force. Now, this does not talk of procedural law. If the procedural law violates Article 21 or Article 14, it's a different matter. Article 21, Clause 1 does not deal with, it's very specific. It is very, very specific. And it may have its extreme consequences, what you say.
No,
One minute.
if we not,
So this really is talking about the substantive law under which you are convicted. Correct? As far as procedural law is concerned, now one may say, why shouldn't this procedural protection be granted to several other cases? Right not to be disturbed is still not recognized fully in India, but indirectly it's now whether we can bring it under Article 21, right not to be disturbed, is a question which may arise in some. It will arise. It's bound to arise with the law which is expanding. So, therefore, we have to be very careful when you are expanding that doctrine to include procedural law. But it's not to say that procedural law should not be fair, because that if it is unfair, it may hit by Article 21, right not to be disturbed, or under Article 14 on the ground of, to be careful on that.
may respond. Lordship is right. If you read it, literally, it's only a substantive law. But a question mark was posed by the Honorable Supreme Court in Constitution Corporation.
We'll deal with it, but
No, your Lordship is right. It only talks of conviction. There is a procedure there. Procedure go to 21. But then there was a reasoning by this court, which was referred to, you're now coming for your Lordship. Now coming to Constitution Corporation, and a very interesting observation by this Honorable Court. And then I'll take your Lordship to the judgment of this scenario. Now, this case was interesting. They started an electricity tribunal in Andhra Pradesh to try people for offences. And what was shocking to my mind was that the tribunal consists of 2 civil servants, and they could conduct a trial and punish people also. So that was not commented upon. Now, Lordship will kindly see. 108 is a judgment of a division bench.
There is the first judgment.
The first judgment. This started the whole 23 discussion. Lordship will just start with page 112. In the beginning, so Lordship will know what was the conspectus of page 112. I read below page 112. This appeal by special leave has been preferred against the judgment and order dated 8/6/2001 of the High Court of Andhra Pradesh, by which writ petition preferred the respondent was allowed, and it was directed that the criminal case pending against them shall not be transferred to the special tribunal, and their trial shall continue in the ordinary criminal courts. Now, please straightaway come to page 114, which introduces a special court. And it had its own special fast track procedure. Lordship will just come to 49D1. The state government, by notification, the official gazette, constitutes a special court for the purpose of providing speedy inquiry into alleged act of theft of energy and trial of cases, and for awarding compensation to the electricity utility. A special court shall consist of chairman and not less than 4 members. The chairman shall be a person who has or has been a judge of a high court, and of the other 4 members, 2 persons shall be who are or have been district judges, and the other 2 members shall be persons with a degree in electrical engineering and who have held the post not below rank of chief engineer in a state electricity board, etc. Then various procedures are given which are different from the normal procedures. Now, paragraph 15, which starts the entire discussion. In fact, Lordship comes to paragraph 119. In fact, no, from para 8 onwards, please come to para 6 at page 116 actually. There, His Lordship starts a discussion on 21. In order to examine the contention phase of the bar, it's necessary to consider the real import of the guarantee extended clause of Article 20 of the Constitution. Then His Lordship goes into pre-independence days. Then please come to para 7, where Section 9 of the US Constitution prohibits bill of attainders and ex post facto laws. And then Lordship knows the Calder versus Bull, which I will come to later if necessary. And then note they place interpretation on ex post facto laws in para 8 at page 117. It will be useful to briefly notice the interpretation based on this constitutional guarantee by US equal under. Then they gave what is the protection under ex post facto law. Now we are on Article 20, and after discussing the various laws in different countries, kindly now come to para 14. Now kindly see para 14, page 121. Concerned as it is with the liberty of a person, a liberal consideration has to be given to the language used in clause 1 of Article 20 and not a narrow one. The interpretation given to section 9 of Article 1 of the American Constitution by the US Supreme Court may also be kept in mind for the purpose of understanding the true content and scope of the guarantee enshrined in clause 1 of Article 20 of the Constitution of India. Now 15 is what about this Khanna, same point is inserted here. With a constitutional guarantee enshrined in clause 1 of Article 20 is confined only to prohibition against conviction for any offence except for violation of law in force at the time of commission of the act, charged as an offence and subjection to penalty greater than that which might have been inflicted under the law in force at the time of commission of an offence, or it also prohibits legislation which aggravates the degree of crime or makes it possible for the accused to receive greater punishment, even though it is also possible to receive the same punishment under the new law as would have been imposed under the prior law, or this is important, or deprive the accused of any substantial right or immunity possessed at the time of the commission of the offence is a moot point to be debated. So here, my lord, His Lordship flags the question: how do we interpret 21? Do we see from a narrow lens, or do we say that 21 carries within it, is pregnant with a substantial right or immunity possessed at the time of commission of the offence charged is a moot point to be debated? The effect of the amending act on the right of the accused to prefer an appeal may be examined for. Then they go to the merits. Then Your Lordship will finally come to. This is the question he raised. Now, please come to para 21. Sorry, para 20 and 21. The High Court in the Indian judgment has held that though in view of the language of subsection 49C, all pending cases may be transferred, so no right of appeal or revision can be taken away, nor can an accused be deprived of a better procedure to 2021. Accordingly, it held that subsection 5 of 49C should be read down, whereas the pending cases nature of the Metropolitan Court cannot be transferred to the Special Court, and the writ petitioner should be tried in the regular criminal courts in accordance with provisions of the so. However, as to the interpretation of Article 20 to scope and ambit involved proceedings, we refer the question formulated in para 15 of this order to a larger bench. And now the larger bench becomes academic. Please come to page 126 and 127. In view of the subsequent legislation, namely Electricity Act 2003, the learned counsel appearing on behalf of the parties say that the matter has become academic. Accordingly, we need not answer the reference made to the Constitution Bench. Consequently, nothing survives in this appeal and the same is accordingly discharged. So, this answer to this question ultimately came literally 12 years later, but now this matter has come before the Lordship. Now, kindly see a very important observation at page 148. As the Lordship mentioned, should we look into 140, 21 also? Now, a judgment of 3 judges, and Lord, majority is Matthew and Mukherjee JJ, and Justice Beg is dissenting. And this was a case questioning preventive detention. Now, Lordship will see, as far as we are concerned, we are primarily concerned with yes. Para 21.
Which page are you reading?
Para 21. Okay. Page is 159. But they strike down the detention. And para 19. Is there. If a ground communicated detainee is the fact that the detainee could have but did not ask for further particular living material, that would be relevant only for considering the question whether the ground is vague or not. Now, Lord, para 21 is very important. And see the spirit with which they read 21. The facts of the cases might induce mournful reflection how an honest attempt by an authority charged with the duty of taking prophylactic measures to secure the maintenance of supplies and services essential to the community has been frustrated by what is popularly called a technical error. We say and we think it necessary to repeat that the gravity of the evil to the community resulting from antisocial activities can never furnish an adequate reason for invading the personal liberty of a citizen, except in accordance with procedure established by the Constitution and the laws. Now, please note, this is what I am stressing. The history of personal liberty is largely the history of insistence on observance of procedure. But it bears reading once again, beautifully put. The history of personal liberty is largely the history of insistence on observance of procedure. And observance of procedure has been the bastion against wanton assaults on personal liberty over the years. Under our Constitution, the only guarantee of personal liberty for a person is that he shall not be deprived of it except in accordance with procedure established by law. The need today for maintenance of supplies and services essential to the community cannot be overemphasized. There will be no social security without maintenance of adequate supplies and services essential to the community. But social security is not the only goal of a good society. There are other values in a society. Our country is taking singular pride in the democratic ideals enshrined in its constitution. The most cherished of these ideals is personal liberty. It would indeed be ironic if in the name of social security, we would sanction the subversion of this liberty. We do not pause to consider whether social security is more precious than personal liberty in the scale of valuation. For any judgment as regard that would be but a value judgment on which opinions might differ. But whatever might be the impact of maintenance of supplies and services in the community, when a certain procedure is prescribed by the Constitution or the laws for depriving a person's liberty, we think our duty to see that that procedure is rigorously observed, however strange this might sound to some ears. Petition that release from custody. So, my Lord, I would humbly request your Lordship, since it is coming now, for interpreting 21 with 21, 20 in bracket 1 with Article 21. To say that the provision, no person shall be convicted, that process of conviction must take into account both the procedural safeguards and the other substantive safeguard, is my humble submission. And I would say don't read 21 isolation, though Justice Mathur doesn't refer to 21. I would request your Lordship that the para 15 of the Transition Cooperation Order, I would humbly request my Lord to say that scope of 20 bracket 1 must be read along with the right under 21 itself. If 21 is a source of derivative rights,
that are
yeah.
really speaking, these observations are with reference to Article 21, not with reference to Article 20.
No, 22. No, but the point is
what? Number 2. These are two separate. Yes, there is an interplay between the rights. There cannot be, cannot say there is no interplay between the fundamental rights. But Article 20 is a very specific nature of protection. And whatever you are arguing will not get diluted whether you bring it under Article 21. But to say that the police should not have any power of investigation or inquiry should be read into as a basic right conferred under Clause 1 to Article 20. By reading the provisions of Article 21 into 20, Clause 1, we will create a lot of issues and problems in a given situation.
No, I appreciate it. But I'm only
Because when we lay down the law, because rights under Article 21 are certainly protected, those have not been taken away. And one cannot say the sanction is the protection given under Article or inquiry or investigation, which is done by a third party, that's the police, because that's where the society, because the very fact that investigation is done by a third party, not by an individual, is the protection.
And Mr. Datar, one more thing. 21 takes care of the procedural part. If procedure is arbitrary, that Article 21 protects you. And therefore, Article 20, Clause 1 remains confined to the substantive law. Because reverse regarding procedure is taken care of by 21.
It may create a lot of issues.
That's right.
It will create a lot of issues because, like 1973, the code changed. There have been amendments also in the Prevention of Corruption Act with regard to substantive, with regard to the procedural part from time to time, because certain amendments were made in 1988, if I'm not mistaken.
But I put it this way. I would humbly request the Lordship not to read 20 and 21 in separate silos. This was done in A.K. Gopalan, and we have got the masterly descendant of Fazal Ali, who his Lordship explained very beautifully what happens if you start taking articles in separate silos. One of the finest descents Fazal Ali is Fazal Ali. Now, I would submit to this bench that an interpretation which advances personal liberty should be preferred to an interpretation which will reduce or restrict personal liberty. Now, my humble submission,
We are not saying what is being, we are not saying that these have to be read in separate silos. What is being pointed out as far as the procedural part is concerned is protected under Article 21. As far as substantive part is concerned, it's protected. It's a very, very specific protection which is given against penalization or criminalization of past acts. It's a specific protection against which bars penalization of past acts, which will not offense at the time when.
Correct. No. So that's the whole part. In fact, in one of the seminars at Bhopal, Mr. Vikram Reddy put a very interesting question. He said, Article 21 is a procedural right. How are you using it to derive rights from 21? That's a very interesting debate. 21 only says no person shall be deprived of his life or liberty except under procedure established by law. How do you get right to housing, right to road, right to Article 21? But the point is, this is where constitutional interpretation matters, where the court doesn't go by the literal language of 21 and say that, look, 21 simply says no person shall be convicted. It is only confined to substantive law. That is a very literal reading. I am requesting, as Honorable Supreme Court in the Constitution Corporation said, please see page 122 once again, madam. Please see page 122 once again, because this is very critical. It all depends how your Lordship is going to view it.
No, Mr. Datar, you are right to the extent that we have to uphold the liberty.
An interpretation which promotes liberty.
No difficulty on that.
Yes. Yes,
All right. You want to go back to
no, you are just saying something I didn't.
No, in any case, there you are right.
Yes.
The question is, if you are protected under Article 21, should we expand the scope of Clause 1 of Article 20?
Yes.
That's the only question.
Yes, my only submission is yes. I am submitting that it should not be conviction. I am discussing with Mr. Amit Desai, most in law more than perhaps more than me should be. That when you talk of conviction, one literal way is conviction of an offense. This is an offense you are convicted. That's the end of the matter. Now, the Supreme Court says, should we rethink it? They go to the various international developments. They go to how the US Supreme Court has interpreted ex post facto law. What is the ex post facto? Is it just punishment? Is it just listening or is it also procedural safeguards? That's why they say deprives the accused of any substantial right or immunity possessed at the time of commission. Will not immunity be a procedural part also? And also, as my friend pointed out, the word law in Article 13 partly, law includes substantive law, procedural law also. Why should we restrict law to mean only a substantive law is my humble question. So I'm just submitting what the Supreme Court has asked us to consider. It's time, this is now 70 years have passed. Let us reconsider the scope of 21. Lordship will kindly see. Or deprive the accused of any substantial right. My lord is right, substantial right. Or immunity possessed at the time of commission of the offence. Now, what is the immunity possessed by an accused? Immunity can be below 5 lakhs, don't prosecute it. That's an immunity. Now, you can't say even below 5 lakhs from retrospective.
That will form part of the substantive law. Let's say, like in the Income Tax Act, for late filing of the return, is a stipulation 1 lakh, which has continued from 1976. That's a different matter because it should have been increased. For late filing or non-filing of return, there's immunity till 1 lakh. So that obviously is a part of substantive law. So even if we delete that section, obviously the past offences will not be covered by it. That's part of immunity. What immunity? What you are referring to here is a procedural investigation, because mere investigation or inquiry does not lead to either. It's a process of investigation. It's an embargo. It's a bar on investigation.
Inquiry or investigation.
It's a bar of investigation. It's not a finding. So really speaking, the provision here, what you are saying is do not investigate, do not inquire.
6A says that.
6A says that.
Yes. I am requesting my lord to say.
Can you say it's covered? The bar of investigation and inquiry will be covered by Article 20, Clause 1.
I am only submitting that when you talk of 20 clause 1, it simply says no person shall be convicted. And that's submitting. If a person has got an immunity from being prosecuted unless you get a prior approval, what does clause 60 say? If your rank is more than joint secretary and above, and that was from there from 1969, we got the Santana committee, all people have said, let public servants not be harassed, therefore they issue some filtration process. They put a cutoff at joint secretary. Why? Because decisions are taken at the joint secretary level, which has got economic consequences. That's the logic. Now, my only submission is, I am only requesting the lordship to construe 6A as an immunity. 6A as an immunity.
From conviction.
No, from investigation inquiry at the very first stage itself. And that's what also discussed in Veeraswamy case, which I'll come to later. Because why in P.Datar they said there is no inconsistency between Veeraswamy and Para 28 and this. One of the questions referred was, is there an inconsistency between Veeraswamy's case and this case? But students on the answer, there is no inconsistency. So I'm not getting into that aspect. I'm only submitting what's the meaning of immunity. If a lordship takes the Hofelden aspect, right corresponding is duty. Immunity is the opposite of privilege. Lordship takes Hofelden Q. What is immunity? The jural corollary of immunity is privilege. But here it will not operate. In fact, one way we have addressed this article, partly doesn't contain only rights, it contains privileges, it contains immunity. So I am only submitting that ultimately lordship has to decide when you are giving an immunity to civil servants, that if you are above the rank of joint secretary, you will not be subject to inquiry investigation without the prior approval of the central government. That should be taken as an immunity, and that is entitled to protection under 21. Now, the judgment of Justice Matthew, up to para 20, he goes into the aspects of government detention, the civil supply, their diverting of essential commodities, etc. Then he comes to 21, and 21 is a passage of universal application. Not simply 20, because the judgment is in the context of what it decides. But there are certain passages of the judgment which go beyond the particular judgment, they go into the human values. And there, they go into the aspect of immunity. And there is also the same thing, if I didn't want to bring that into expanded the whole scope. Please see the dissenting opinion in Jabalpur, idiom Jabalpur. From Magna Carta, they go to and say this ultimately, what is the liberty? The liberty is a compendium of substantive rights and procedural rights. A liberty can't be taken as substantive right. If I have got procedural safeguards, if I am above the rank of joint secretary, one filter is there. Go to central government approval. So I made my point. I leave your lordship to see how your lordship wants to interpret it. Because look at the other way of looking at it. A person has got immunity for all these years. Forget Subramanian Swami. Suppose 6A had given this immunity and Parliament wanted to amend the law retrospectively. I dare say that it would be a very strong case for me to argue that this immunity was given to me from 1969, made it into a statute. Statute continued for 10 years. Now in 2014, forget the Supreme Court. Suppose Parliament in 2014 said no, 6A is invalid from 2004. Retrospective amending it. I would humbly submit that the Supreme Court would strike it down, not only on grounds of arbitrariness, but on the grounds of 20 subsection 1, clause 1. You could not have even started the trial with the joint secretary. Where's the question of convicting him? And therefore, I am asking the protection in respect of conviction. In respect of lordship interpreted liberally. Now, if a marginal note, generally not important, but if the lordship is interpreted 20 for the first time, which is the direction we want the country to go? Are we going to say 20 is just restricted to substantive law? Or is it time to say 20 encompasses all the immunities, all the protection? I would say immunity, a better word would be protection. Safeguard. These are all synonyms of immunity in the context of Justice Mathur has said. So immunity will mean safeguard, will mean protection. All these things are part and parcel of the 21 right. Take it as a prosperity, nobody says no.
What you are saying, Mr. Datar, is
Yes.
that where a court would look to uphold the retrospective action of the legislature, don't give an interpretation where the court would be doing the same thing.
Yes. So Andule judgment can't violate Article 14 after this Viraskar's case. So there was a small deviation on Andule, but that's a different. So this is my submission as far as it is. The subject to what AG says, this is a strong statement. And I'm only submitting. I didn't want to come to the lordship. If your lordship gets time to see the judgment of Justice Supreme Court in Constitutional Power, his lordship starts at page 116 and then kindly come to page 117. Because his lordship starts reflecting what is this ex post facto law. Please come to page 117. Now, see para 7, section 9 of Article 1 of the US Constitution as interpreted, of this as adopted on 4/7/1776, provided that no bill of attainder or ex post facto law shall be passed, and section 10 of the same article lays down that no state shall pass any bill of attainder or ex post facto. The import of this constitutional guarantee was explained 2 centuries ago by US Supreme Court in Kaul versus Kaul, and lordship will just see item number 4. Every law that alters the legal rules of evidence and receives less or different testimony than the law required at the time of commission of the offence in order to convict the offender. So, legal rules of evidence. Why not we take it as protection also granted? I'm not talking section 25, 26, statement made to a police officer, etc. I'm saying the ex post facto laws, if it can go to protect legal rules of evidence, why can't it protect other immunities also granted?
You, after lunch, take us to anything else, or you would like to, from your note, you will take us to something?
Yes, I'll take a note. So I'll just go to now, post lunch, I'm going to go to the effect of the lordship declaring under 14. Is it void ab initio, still bond, etc. Two is wide to extended contraventions. The effect of the meaning of the scope void came up for consideration in a number of cases from 1951 to 1963, and been set out as numbers 8 to 14 in the case of compulsion. These judgments use words such as morality, stillborn, bed, etc. Further observation made in some cases of the declaration of unconstitutional compliance with the law was never in existence before. However, in the several judgment given in May 11, Supreme Court considered these earlier cases in para 11 rules and held that American decisions could not be relied to interpret Article 13. It was then held that the law of self-constitution would be inoperative and once placed in 19 would assume fifth post in the year. Because the earlier views were no longer valid. Earlier views of stillborn, etc., this is not correct. It is submitted that the word wide in 13.2 would only mean that the law becomes inoperative or ineffective once it is declared to unconstitutional. Such a law cannot be declared as void and arbitrary for the following reasons. As there is a presumption of constitutionality, there are laws declared to contravene the provisions of Part 3 or other constitutional limitations. It remains valid. The expression to the extent of contravention implies that there has to be a judicial declaration of contravention and the extent thereof. If such declaration is made, no law can be declared as void. If there is no interest, law has to be implemented, and all acts taken pending finally will not become law. The word void is used 14 times in the Constitution. The use of the word void in the context of the Constitution would be unlike the Compact Act, only means that the judicial declaration renders the law inoperative or unenforceable. The Oxford Dictionary defines the word void in two ways. As an adjective, it means that something is not valid or legally binding. And as a verb, it means to declare something is not valid. Use the word voided. A combined meaning of Article 249 or 251 read to 254 shows that the word void basically means invalid or inoperative. But I have taken this from a book by Justice Maheshwari of the Delhi High Court, who discussed some of them. And then he refers to 249 and 250 and says, void will only mean invalid or inoperative, not void has been issued, stillborn, etc. G. The word void does not mean repeat. The judgment does not amend or alter the statute. It remains in the statute, but cannot be predicted. Article includes the express fundamental rights, but certainly derivative rights. Therefore, it will be incorrect to treat a constitutional unconstitutional law as void as an issue. Theory of second act. The constitutional declaring administrative act as void is subject to several articles and discussions in the UK and other common law countries. It has been held that an administrative act will declared invalid continues to have legal effect. Actions taken while the law was declared invalid, till the law was declared invalid, would remain protected. This is popularly referred to as the theory of the second act. This has also been discussed in the landmark article Metaphysics of Morality. The declaration of invalidity and the consequences that follow are two different aspects. In several cases, the courts have granted relief for taking actions during the pendency of litigation. But I have quoted 11 judgments where the courts have said, though it declared a particular provision to be invalid, since acts have been done, public interest involved, so we are not.
That option, Mr. Datar, is always open.
Correct.
It's not been done here now.
That's right. Now, the main thing is, suppose the court doesn't do it involved.
In the wider context of what you said before this paragraph,
Yes.
how would you say it will operate if the principle, if a provision of law which is capable of criminal prosecution is declared null and void? Would you say it will preserve everything? Suppose there is a
Correct. Suppose there is a law which
reverse thing, it's a protective law.
Yes.
That's a prosecuting law.
Yes.
How will it emerge then?
No, and exactly. What these 11 cases say is depending on the facts and circumstances of the case. What is the nature of this
Today, we can't go into history of what should have been done in the judgment. We are today faced with the judgment.
Yes.
Constitution Bench. And are we required to go into these issues, or we'll have to construe it from point of view of that there was a law which was, as I said, at the cost of repetition, a law which was protective in nature and was struck down only on the grounds of arbitrariness because it sought to seclude some people from the protection while including other people from the protection. My concern is in this larger context in which what you are making a proposition, it can create reverse problems. If were we to agree with what you are saying here and preserve all acts done Look at the reverse scenario.
No, I'm not saying it's a universal principle that you must always do the act. Like, for example, I mentioned the case of 303 of the IPC, where the Supreme Court struck down mandatory death sentences. Suppose the High Court had issued a sentence of making mandatory death sentence. Matter is pending an appeal to the Supreme Court. Meanwhile, Bitu's judgment comes. Can you say sorry? On the date on which you were sentenced to death, that is the law, no, you can't help. I'm not saying that. I'm only saying that the whole difficulty arises is the argument is that once the law is void, it is void from beginning itself and nothing survives on that. I'm saying that's not a law of universal point. And I'm sure you're not saying what I meant. What I'm saying is, I'm not canvassing the proposition. Fortunately, here, there is no, it's not a binary. It will have to be molded, it will have to be molded depending on the nature of what is struck down. After it is struck down, what is the consequence? The reason why I'm giving these cases with the footnotes is the courts have gone into the question. We have struck down a subordinate legislation or struck down a statute. What is the effect of that?
Are we interpreting the judgment of Subramanian Swamy here?
No, what we are now saying is Subramanian Swamy has to interpret it saying that the judgment will not have retrospective because of the protection of Article 23. That is the point. And we are now saying that the judgment cannot take away rights ex post facto, which the legislature cannot do because of the language of
To that extent,
yes.
I understand that.
Yes. So now the point is what happens when a law is declared to be void? That is the question. Because since the Lordship is sitting in a five-year bench, and my lords in the High Court and the Supreme Court have occasion to frequently declare a particular statute as invalid or a subordinate legislation invalid, what is the effect of that? Because still today, except Vikram, which is very goes to the context of 9th schedule in the context of Article 31B because of the language of 31B. Can we say that it's not necessary that every judgment is always introspective? Every judgment always does not make it void from the beginning, and we should.
But did Mafatlal also deal
Yes, Mafatlal said.
with the context of tax statute there?
Correct. What Mafatlal said is that if suppose a particular law is struck as invalid, only litigants who have actually challenged it can get the benefit of refund.
Correct.
They said that if you
Past
have not
assessments will not get affected
yes. And
where they have attained finality.
yes. In fact, the Vodafone judgment also, which was retrospective from 1462, the moment the law was retrospectively amended, they issued a board circular of 500.
Where the suspends are.
Suspended of final, they will not be disturbed.
But that's on question of legislation.
Correct. No. Actually, you may say that circular is invalid, the section doesn't say so. But generally, the law is.
But that circular is in the context of the legislation.
Yes.
But Mafatlal specifically dealt with the situation
Yes.
where the assessments had concluded and with passage of time had attained finality.
Yes.
And even in NAFED matter, what was clarified where there was an amendment made in NAFED matter, it was clarified that the way where the principles of res judicata apply, those will not get affected by the legislation. That is a different context.
No, in fact, in taxation, your lordships from this Petitioner judgment, they say that where you have passed on the benefit, I am not to get the benefit because Article 26 ultimately is equitable relief. So in equity, and it's right down the law. That I may still say that if you have passed on, you will not get the benefit, the person who has passed on the benefit. That's the law made for retrospective amendment, the amendment 11B of the Central Excise Act. And now, almost all tax laws, the universal principle is if you have passed on the benefit, then you can't be adversely enriched. So there is no problem. So to answer this also question, I'm canvassing for the proposition that the court should not hold that the declaration of invalidity always operates from the beginning. It's not necessarily so. And the legal difficulty is best highlighted in one English judgment that I'll come to this as a prediction more. But I'll go to that English judgment straight away. Please come to my compilation. Why I'm using in one page, the learned judge summarizes the difficulty which constitutional courts are going to face. He says, UK, you don't have the problem. But in countries where the courts can strike down the law, what is the problem? That he has. Now, the judgment starts at page 360. Sorry. Now, what should we just come to page 376? Just the first paragraph will show what is the controversy. Then I'll move to only that page. Read.
Just one.
move from the statute book, it continues there. Even if the Lordship sees P68, P68, 4 and 5 were declared to be violative of basic structure of mineral laws, but it is still there in our Constitution. NJC, struck down, still there in the Constitution. Now, Lordship will kindly see 197, page 197. On the right hand side, the amendment, reading in the top, the amendment to the Constitution which came later cannot be involved to validate an earlier legislation, which must be regarded as unconstitutional when it was passed. As Professor Cooley has stated in his work on constitutional limitations, the statute void for unconstitutionality is dead and cannot be vitalized by a subsequent amendment to the Constitution, removing the constitutional objection, but must be reenacted. We think that this is sound law, and our conclusion that legislation in question violates fundamental right of the appellants in 1913, not protected by 1906, must be held to be void as against rules. Now, this passage was subsequently found to be not correct. Then Lordship will come to the next case, which is the case of Behram, but I'll just come to Behram later. Please come to the next case, which is post Constitution 13. Which is NP Sudrama. But I'll to save time, I'll straight away come to Deepchand. And Mahendralal Jain. Deepchand is 1959. And Lordship will kindly see. Mr. Subbarao goes into the discussion that it is still born. But Chief Justice Das makes the caution. Kindly started at page 274. PC Para 3. Principle laid down by that. They say that the law doesn't violate Article 31. But now please see Para 3 at page 274. In view of the aforesaid finding that the UP Act did not infringe the fundamental right guaranteed under Article 31, it is wholly unnecessary to discuss the following question, namely, whether the provisions of Part 3 inherent fundamental rights are mere checks or limitations on the legislative competence and the state legislature led with the relevant entries in 7th schedule, or an integral part of the provisions defining, prescribing, conferring, so B, whether doctrinal eclipse is applicable only to pre-constitution or can apply to post-constitution, which falls in Article 13(2). As however, our learned brother has sought fit to embark on a discussion, we desire to guard ourselves as being understood as accepting or accusing the conclusion that the doctrine of eclipse cannot apply to post-constitutional law. Post-constitutional law may infringe either a fundamental right conferred on citizens or on fundamental right on citizens. In the first case, law will not stand in the way of the exercise by the citizen of fundamental right, and therefore will not have any operation of the rights of citizens, but it will be quite effective as regards non-citizens. In such a case, the fundamental right will pay citizens throw a shadow on the law, which is nevertheless in the statute book as a valid binding source. Now, Lord, come to the next page for 8 lines on the top. Whether a post-constitutional law of the other kind, which includes fundamental right, guaranteed to all persons, whether citizens or not, which therefore can have no operation of law, and whether it enacted is to be regarded as stillborn law, as if it had not been enacted at all, therefore not such a document. It's a matter which we open discussion. The finding right there, or a discussion on these aspects do not call for a considered opinion and result. Nevertheless, not the majority of this Subbarao, they go and say it is completely stillborn, that is at para 13 and 14. The Lordship will kindly come where they say, just come to just above para 14. But before I come to this above para 14, one point Lordship will kindly recommend is going to come to later. The Lordship can declare a law as unconstitutional on the ground of lack of legislative competence, not on the ground of fundamental lack of legislative competence. Lordship can also declare it as invalid, violating Part 3 or any other article, Article 286, 265, 301, Part 3. Is there a difference between these two laws which are applicable? In Veram Vesika, the matter first came before 3 judges. And Justice Venkatraman, he said that there is a difference. If a law is struck down for lack of legislative competence, it is void, it is a nullity. And even if you get competence later, you must re-enact the law. It is completely dead, it can't be sued. But if a law is violative of Part 3, then it is not wiped out, it is still there. And if you remove the infirmity, it will become operative again. And this is the view taken by Venkatraman and Veram Vesika, the 3 judges. Because of there's a review of that judgment. And in the review, they posted before 5 judges. Before 5 judges, the 5-judge bench said there is no distinction between each kind of striking down. Whether you strike down legislative competence or Part 3, both are the same. So it should have been taken and settled with Veram Vesika that it was completely closed. Despite that, with due respect, in Sundaramaya's case, Venkatraman once again takes it up and again reiterates that principle, saying that with legislative incompetence, the law is dead with reenactment. If it is fundamental rights, there is no reenactment, the law is there, you can always bring it to life later. Now, please see now in Sukar's case at page 278. Now, what's your parents? At page 277. Just the highlighted portion of page 277. A distinction is sought to be made by the General Advocate General between the law made in excess of the power conferred on the legislature and the relevant lists in 7th and that is violation of the provisions of Part 3. The former it suggested goes to the root of the legislative power, whereas the latter it said operates as a check on that power. The result that the law so made is unenforceable. As soon as the check is removed, the law is disinstated and becomes operative from the date the check is removed by the constitutional amendment. Then they refer to Mr. Nambiar's argument. Now, what's your kindness? Yes. At page 278. Just come to the highlight portion at 278. There is a clear distinction between the two clauses. What's this got it? Page 278.
Yes.
Under clause 1 of pre-constitutional law subsists except to the extent of inconsistency in the provisions of Part 3, whereas no post-constitutional law can be made contravening the provisions of Part 3, and therefore the law to that extent, though made as a nullity from its inception, of this clear distinction is borne in mind, much of the cloud race is dispelled. When clause 2 of Article 13 states in clear, unambiguous terms that no state shall make a law which takes away or abridges the rights conferred by Part 3, it will not avail to the state to contend either that the clause does not embody a curtailment of that power to legislate or impose only a check but not a prohibition. A constitutional prohibition against a state making laws cannot be written down by analogy or drawing inspiration from decisions of other constitutions, nor can we appreciate the argument that the word any law in the second line of 32 posits survival of the law made in the teeth of such provision. It is said that once a law can come into existence only when it is made, and therefore any law made in contravention of that clause, principle the law is not a nullity. Argument is subtle but is not sound. The word any law in that clause can only mean act passed or made factually notwithstanding the provision. The result of such contravention is stated in that clause. The plain reading of this clause indicates without any reasonable doubt that the prohibition goes to the root of the matter and limits the state's power to make the law. The law made in spite of the prohibition is a stillborn law. Deepchand and Maheshwari they use the word stillborn law. Now, I wanted to just point out where there is no distinction. Please come to page 201, where I am basically. Page 201. First, the judgment starts. And Lord note the benches, Justice Bhagwati, Justice Jagannatha Das, and Venkatrama here. Now, here, the Lordship now comes to the judgment of Venkatrama here. To that page 210. I regret I am unable to agree with the view of Learned to the Bhagavati. Then Lordship will write invalidity in two ways. One is lack of legislative competence, and the other is violation of fundamental rights. And there, please come to para 36. Lordship will quote para 36 at page 213. Another point of distinction noticed by American jurists between unconstitutionality arising by lack of legislative competence and that arising by reason of a check imposed on a competent legislature may also be mentioned. While a statute passed by legislature which had no competence cannot acquire validity when the legislature subsequently acquires competence, a statute which was within the competence of the legislature but which infringes a constitutional prohibition could be enforced proprio vigore when once the prohibition is removed. Law is thus stated by Willoughby. The validity of a statute is tested by the constitutional power of the legislature at the time of enactment by the legislature, and if thus tested, it is beyond the legislative power. It is not rendered valid without reenactment later by constitutional amendment. The legislative power is granted. However, it has been held by where an act is a general legislative power, but is rendered unconstitutional by reason of adventitious circumstance. For example, state legislature prevented so and so. The Federal Congress has already legislated. Then there should be no regulation. That need not be reenacted in order to enforce. Now, this was the Lordship just up to page 216. Review is granted, and at page 270 is a bench of 5 judges. The Lordship now comes to para 11 at page 220. What is para 11 and 220? Para 11. We are also unable to endorse. We are also unable to endorse the opinion expressed by 11 to the Vikram that a declaration of unconstitutionality brought about by lack of legislative stands on a different footing from a declaration of unconstitutionality brought about by reason of abridgment of fundamental rights. We think that it is not a correct proposition that the constitutional provision is partly of our constitution, merely operate as a check on the exercise of legislative power. It's axiomatic that when the law-making power of a state is restricted by a written fundamental law, when any law enacted and opposed to that fundamental law is in excess of legislative power and thus a nullity, both these declarations unconstitutionally go to the root of the power, and there is no real distinction between them. They respect but two aspects of want of legislative power. The legislative power of Parliament and state is conferred by Article 245 and 246, stands curtailed by the fundamental rights chapter of our Constitution. A mere reference to provisions of 13.2 and 245 and 246 to indicate that there is no competency in Parliament is to make a law which comes into clash with the so. This is clear from the mandate of. So, Malak, the 5 judges said that there is no distinction between that. Unfortunately, despite that, in NPP Sundaramaya's case, this Venkatramaya once again says that there is a difference. Now, Lordship will kindly see at page 237 the judgment starts. And if the Lordship now comes to page 258. Para 42 at page 258. Now, in considering the effect of unconstitutionality, it is necessary to remember unconstitutionality might arise because the law is not within competence or because. So, this is my humble submission, ought not to have been done. But anyway, my submission is this point is dealt with later by Justice Matthew in 1974. He says, lack of legislative competences, you are restricted subject-wise, whereas in 13.2 you are restricted right-wise. Both are inhibitions against you. One is an inhibition where the subject matter. Article 245, 246 says, sales tax, state government, income tax, and so that bar is subject-wise. Whereas 13 to the bar is right-wise, you not violate constitutional fundamental rights or other provisions. Now, please come to the last Ambika judgment. Page 327. But very interestingly, for some reason, Article 19 is only for citizens. So if it's a company, you know, that most business is carried on by the company, there is no fundamental right to carry on business by a company. So some people suggest that you amend the Citizenship Act and say for the purpose of citizen can include a company. But that's why we make the company as a petitioner one, we make somebody else as a petitioner number two after the System Cooper and the DCM case. Now, here what happened is, this is Matthew, Lordship kindly. His Lordship kindly come to page 334. What he says is, the particular labor law is violative of 19(1)(g). It may be invalid to citizens, but it is perfectly valid to non-citizens. So, right to form an association if I prohibit a non-resident or a non-citizen from doing it, the law violating 19(1)(d) will be invalid to citizens, but perfectly valid to non-citizens. So, a law can exist invalid to citizens, but valid to non-citizens. And Lordship will just come to page 334. From para 28, his Lordship discusses the entire law. Just from para 28, his Lordship discusses. And now Lordship will kindly come to page 334 and yes. Now, kindly come to para 36.
Yes.
Yes. If the meaning of the word what is 13(1) is the same as 13(2), so you could understand why a pre-constitutional law which takes away abridges rights under 19 to remain operative even after the Constitution came into force as regards non-citizens, and the post-constitution which takes abridges inoperative respect non-citizens. The fact that pre-constitutional law was valid when enacted can afford no reason why it should remain operative as respects non-citizens after the Constitution came into force, as it became void on account of inconsistency with Part 3. Therefore, the real reason why it remains operative as against non-citizens is that it is void only to the extent of its inconsistency with the right conferred by 19, and its voidness is therefore confined to citizens as next hypothesized. The law cannot be inconsistent with their fundamental rights alone. If that be so, we see no reason why a post-constitutional law which takes away or abridges the rights conferred by 19 should not be operative in regard to non-citizens, that is void only to the extent of contravention of rights conferred by citizens. Now, Article 13 is an injunction to the state not to pass any law which takes abridges fundamental rights. And the consequence of the contravention of the injunction is that law should be void to the extent of the contravention. The expression to the extent in the sub-article can only extend to the contravention of rights conferred on that part. Rights do not exist in vacuum. They must always be inherent in some person, natural or juridical. And under Part 3, they are even fluctuating bodies like the linguistic or religious minorities. And when the sub-article says the law will be void to the extent of contravention, it can only mention it means the extent of the contravention of rights conferred on persons, minorities, denominations, or religious community. Then the law will kindly come to para 43. Please go to para 42 first. Mr. Wade has argued considerable force that the terms void and voidable are inappropriate in the sphere of administrative law. According to him, there is no such thing as voidness in absolute sense. So the whole question is void is against whom? And he cites the decision of pre-council in Duriya process. Now this para 43 is important. In Jagannath was the authorized officer. The court has said that the post-constitution act, which has been struck down for violating fundamental rights conferred under Part 3 and was therefore still born, has still an act existence without enactment for being put in the ninth schedule. That only illustrates that any statement that law which takes away or abridges fundamental rights conferred under Part 3 is still born and null and void requires qualification in certain situations. Although the general rule that the statute declared unconstitutional is void at all times, and its validity must be recognized and acknowledged for all purposes, and there is no law and validity. This is neither universally nor absolutely true. So for the first time, after Jagannath, this is Matthew who just squarely and says, there is no universal validity, there is no universal point that is. A realistic approach has been eroding the doctrine of validity in all cases and for all purposes. And it has been held that such broad statement must be taken with some qualification that even an unconstitutional statute is an operative fact. It's an operative fact. At least prior to the determination of constitutionality. So, my lord, an unconstitutional statute is an operative fact at least prior to unconstitutionality and may have consequences which cannot be ignored. This is illustrated by source. So, my lord, the net result of this discussion, I am complete Jagannath, which is a 7 judgment. All these judgments are 5 judges. Keshav Mahadevan was 7. Then the next 7 judgments held Jagannath. And if your lordship now comes to this particular provision. Now, this case shows that a law which is struck down is not a nullity, is not obliterated. If it is stillborn, then it is dead from the beginning. But what this case says is, if a law is struck down, Parliament can always put it on the next schedule. So it will be paradoxical to say it is dead. And if it is dead, how can we put it in the next schedule? And that's what this court says, that don't use the word stillborn, don't go by American principles. Now, kindly see, my lord, here certain Madras laws were struck down, land reforms, and they are put in the ninth schedule. Now, for our purposes, lordship will kindly see. Please come to page 380. 18.
1-8.
Yes. They start with Veram basic Akka, then again the 7 judges brought, they discuss the entire law, right up to Sundaram, right? And lordship will now come to para 22 at page 3. In our view, although decision of the Sumerian Supreme Court and comments of well-known commentators like Willoughby and Cooley have great persuasive force, we need not interpret our constitution by too much reliance on them, nor is it necessary to scrutinize too closely the decision where it used appears to have been expressed that a law which is voided under 13(2) is to be treated as stillborn. Equally unfruitful would be to consider the doctrine of eclipse. Frankly, from my side as a student, I don't see why doctrine of eclipse should not upgrade to post constitutional laws. Suppose the Income Tax Act is struck down. I say beyond, some case tax laws are struck down beyond, say, 1854. The Constitution is amended. Why can't it require life? I don't see. Now, but let me go further. Apart from the question as to whether fundamental rights originally enshrined in the Constitution are subject to amendatory process of 368, it must now be held that Article 31B and 9 schedule have cured the defect if any in the various acts mentioned in the said schedule as regards the Constitution has been alleged on the ground of infringement of fundamental rights. And by the express word of 31B, such curing of the defect took place with retrospective operation from the date on which the acts were first put to the statute book. These acts, even if void or inoperative when they were enacted by reason of infringement of 13(2), assume full force and vigor from the respective dates of their enactment after the inclusion of the 9th schedule under the Article 31B. The state could not at any time cure any defect arising from the violation of Part 3. Therefore, the objection that the Madras sealing should have been re-enacted by the legislature after 70th Amendment cannot be accepted.
Mr. Datar,
Yes.
isn't this observation in light of Article 31B?
It is. No. But
Because Article 31D said retrospective. So really speaking, then it took away the theory of stillborn completely by legislation.
correct.
By legislation, it negated that theory of stillborn. So therefore, the context in which the submission is made, the observation, the ratio is given, is in the context of Article 31 capital B.
Yes. But I put it this way. Lordship knows the First Amendment was also retrospective because of all the Lordship knows the history of 31B, etc. Now, 31B says that no law which is based on the ninth schedule shall ever to be deemed to be void. So it gives life to that also. So no doubt about it. But the reason important of Jagannath is how do we interpret the law from Veram Deepchand, Mahendralal Jain, in the line of cases. Is the law validity? Because if the Lordship is going to hold it at 13.2, the declaration means the law is at validity. Then there is no law at all. Different consequences arise. I am using Jagannath to say that a 7-judge bench has gone into the entire question and said all the 5 judges are referred to Cooley and Willoughby. But see, all the other judges are referred to American Constitution. 7 judges says don't interpret Turkey on the basis of the Constitution, on the American. Secondly, I am submitting by analogy. Lordship is right. This is on 31B. But I can always take the benefit of the judgment and say, what is the meaning of this particular judgment? If you say a law is stillborn, that it is dead from the very birth, then even 31B can't give life to it. Because
They were something different.
because why I'm saying just one minute. The Supreme Court uses the word void or inoperative. They don't say stillborn. And I repeated endeavor to your Lordship is when your Lordship is sitting either in the High Court or in the Supreme Court, Lordship says Section 6 of the Excise Act is unconstitutional. It only means Section 6 becomes inoperative. It doesn't mean it's a nullity from the day the Act was actually made, 1944 or whenever. That's all I'm trying to say.
That's fine, but the issue, because here the issue was not, therefore directly the issue was not whether whether the earlier decisions, Percy etc., Percy Kaka was laying down the right ratio that when a law is declared, suppose, like in this case, 66A is not being now brought in the 9th schedule, so what is effect thereof? But really speaking, the net effect is whether you call it stillborn, ineffective, or whatever it is, it cannot be enforced.
And Mr. Datar, the further part says that very specifically. Same paragraph which you read, if you go down,
Yes.
it perhaps says what further just and I say.
So sorry, which part?
Paragraph 23.
Yes, yes.
He stopped at
Lower
first part.
No, yes. Lordship will kindly see. These acts, even if void or inoperative, at the time when they were enacted by regional infringement, assumes the force and rigor from the respective dates of their enactment after their inclusion in the 9th schedule. So suppose a law was made in 1966.
That's right.
It was struck down.
It reiterates that on the date on which Act is enacted, it becomes void and inoperative. And only in one contingency where it is included in 9th schedule, it will be 31B.
Yes.
And it is distorts. And read even next sentence.
Yes. The state could not at any time cure any defect arising violation, and therefore objection that Madras ceiling limits have been reenacted by the legislature cannot be accepted. Well, why this is important in the context of the line of cases is this.
No, but what it says is state could not at any time cure any defect arising from the violation of provisions of Part 3 of the Constitution.
Yes. What it means is, suppose your Lordship holds the law to be unconstitutional or not violation of a particular constitutional provision, then it requires a constitutional amendment. Typically speaking, unless it's an Article 14 violation, where the classification is bad, then you need not amend the constitution. But suppose, like for example, in the case of Mandal, you hold the something reservation can't cross 50%. Then you necessarily have to amend 16.4A and 15.4A and then make 15A more than 50% permissible, because then you are really amending what the Supreme Court has declared the constitutional interpretation.
No, what Supreme Court seems to be saying is
Yes.
that if it is declared as a void,
Yes.
being in violation of Part 3,
Yes.
it is void and inoperative from the date, but only in case where it is included in 9th schedule that it revives.
Yes.
But the law, as understood in earlier judgments, is retained.
No.
Court considers the contingency where it is put in 9th
No,
schedule.
in fact, with great respect, is just, when I say so with great respect, the petitioners argue that you can't put the matter into the 9th schedule because the earlier judgments have said the law is still gone, they are nullity, they are from the beginning, it is never there, it has to be reenacted. All those judgments are referred to from page 318 onwards. Then they say that in our view, because if the earlier judgment was there and if the law was held to be still gone, kindly see. Yeah, we need not scrutinize too closely the decision wherein views appear to have this particular still gone. The judgment would have gone further and said these all judgments are bad law. What I'm saying is, the Lordship kindly sees on page 318 onwards is exactly what departure they made. Lordship will kindly see, please see para 9. Para 9, very good, at page 318. On the first, the learned counsel's contention may be summarized as follows. Well, in fact, it is better if your Lordship kindly sees the whole discussion. Response. Please come to para 17. The Lordship has got in the mean para 8. Yes. The Lordship kindly see. No, I think Lordship will start at page 315 so that the whole thing is very clear. Now we have to decide whether the judgment really gets over the earlier judgment. Please see page 315. In all the above matters, there is a common attack on the validity of the Madras Land Reform Fixation of Ceiling Act. The Act received assent of President on 13th April was published in the Gazette on 2nd May. It was styled as so. And Lordship will straight away come to scheme of the Act, etc. Now, please see what para 5. Para 5 at page 316. The Act was challenged by writ petitions filed in this court in 1963 on the ground that they violated 14/1932. The first attack was on section so of the Act, on the ceiling. The second, section 50, read with schedule 3. It was urged that the Act was not protected by Article 31A, relying on judgment of unicommon. This court made definition of artificial and resulted in discrimination between persons equally violating Article 14. This court also held the provisions contained in 50, read with the second schedule, were also discriminatory, and these two sections being pivotal positions, the whole Act is settled in Constitution. The judgment was delivered on 9 March 64. It appears that similar attacks were made not only to our Madras Act, but to several acts of other states imposing ceiling limits on holding of land and attempting to effect agrarian reforms. To shield those acts, Parliament passed the Constitution 17th Amendment Act on 28 June 1964. The statement also says. Then please see para 7. The 17th Amendment was itself challenged in Sajjan's. A number of petitions were filed under Article 32. Challenging not only 17th Amendment but also 4th Amendment. So the first petition group of cases was filed by a group of persons against an order made by the Finance Commission of Punjab holding an area of 487 acres. It was surplus in the hands of petitioners under the provisions of Punjab security. 5 learned judges of this court held that all the amendments were valid, while 4 others concurred in the judgment delivered by Subara, holding that though the above amendment abridged the scope of fundamental rights, violating Article 13, they could not be struck down because of earlier decisions. One judge took the view that the fundamental rights outside amendatory process. Judgment in Goloknath case was rendered on Sunday. In the meanwhile, a large number of writ petitions were filed in the Madras High Court in 64 and 65, challenging the validity of Madras Act, and that main attack was twofold. It was urged that the Act having struck down by this court in special summary, it was honest and void ab initio, and Article 31B could not validate it without a separate validating Act being passed in the Madras legislature. And secondly, the Act was incompetent for want of legislative power. The second attack was leveled on a wide front before the Madras High Court, but before us, Senate Council did not go so far to challenge the legislative competence. Now, this paradigm is important. On the first, Senate Council's contention may be summarized as follows. He urged that this court, having declared the ceiling act void under 13(2), we must proceed on the basis that the legislation was void ab initio, inasmuch as it did not lie within the power of the state to make any law which abridged the rights conferred by party of the Constitution. In other words, it was held that the measure was honest or stillborn, and any other validating measure could not still lie therein. It was argued that the effect of the act being struck down by its court was as if it had been effaced from the statute, and to make any act operative, it was necessary not only to give protection against the violation of fundamental rights, as was sought to be done by 31B, but to get the state of Madras to re-enact the provisions thereof. Then a council drew our attention to several decisions in support argument, we should take note. Then they started. So they take the basis of the argument.
Just see, paragraph 15, what was the argument of learned Attorney General, which was accepted? It was accepted only in light of language used by Article 31B.
Yes,
So this judgment really considers only in a different conspectus
yes,
that what is the effect of act being put in 9th schedule,
yes.
and that is because of language of 31B. If you see paragraph 15,
15, I'm coming to
paragraph 15.
On behalf of some of the respondents, the Attorney General of India argued that no reenactment necessary. Our attention was drawn to the wide scope of 31B, which sought to cure the defect of any in the acts specified in the 9th schedule, that any such act or provision was inconsistent or took away the provisions of so and so. The word 31 made it amply clear that it was sought to be not only prospectively but retrospectively. None of the acts shall be deemed to be void or ever to have become void on the ground of inconsistency mentioned. The removal of the defect was to happen, notwithstanding anything judgment accepted. In other words, this meant that if any defect had been subject matter to this court and any provision had to be void and constructed, such degree was to be inoperative. In effect, it was contended that the inclusion of the act in the 9th schedule to the Constitution overrode and rectified all defects in the act because of inconsistency of the provisions with any fundamental rights of Part 3 as to the date of the Constitution, no matter what the defect. But that does not mean that the act becomes stillborn.
Actually,
DC 31B.
just 1 second. Here's the thing. If it is not put in 9th schedule,
Correct.
the original
Going by your argument,
I want to 31B. Can you also-
leave 31B for the time being.
Yes.
Suppose 31B was not there. The defect pointed out, even in case of a procedure, they say, suppose the legislation had rejected section 6A with retrospective by removing those clauses or saying we are removing this part altogether, or by removing the words offending word, applying it to other cases, all other cases, as though it may not happen. Let's forget about this case, it may not happen in this. But in another case, suppose on the ground of principles of national justice, a political particular enactment is struck down and with retrospective effect, this provision is provided for the effect is taken. Obviously, it will require an amendment. It will require a new enactment. It will not be retrospective, otherwise it will be a huge problem.
But I'll put it similar.
It will be, that's why, and 31B itself was not under challenge in this case.
No, 31B was uploaded in Sanjiv Prasad.
So it was not under,
No, I'm not. See, 31B is uploaded in Sanjiv Prasad. Yes, Sanjay Singh and Golaknath, they struck it down again. Yes, not on that. But I'm only on the point, logic declares the law is invalid. Is it stillborn? Is it nullity? For there I'm saying the early observations were found to be wanting in Jagannath's case, maybe in the context of 31B. Now, 2 points I'm making in 31B. 31B need not be where the act is struck down in the by a court and then put in the 9th schedule. There are many enactments, like so many land reform legislations, MRPP Act, so many acts. From the enactment itself, they put it into the 9th schedule. And that has been discussed fully in Koido's case. What they say is, Parliament can take a law and say this is meant for land reform and putting it in the 9th schedule. All the nationalization acts, not just for textile acts, straight away went to the 9th schedule. They were not challenged first and then went to the national. Straight in the 9th schedule. Also, MRTP have also put saying it's applicable of the 9th schedule. Now, what I'm submitting is, suppose the law tomorrow declares a certain provision of the income tax act is invalid. I'm saying that section is not still on. Tomorrow they can again make a retrospective, invalidate it again. Because what they say has to be validated, enacted afresh. I'm saying it's not necessary to enact afresh. Just because we are only the question of by Subramanian Swami declaring 6 years.
That's not really relevant for us. How?
Correct. No. I'm only saying what my main argument is 20, which I have finished. I'm only saying the logic of sitting and this is all also with the question when you strike down the law, what is happening? Can we say the law is still on, void, abolition, etc.? I'm saying those don't use those words still on, dead, etc. Say inoperative, ineffective. That is the proper terminology to use. Because when you say still on,
Let's not go into a hypothetical case because it will be
correct. So I'm only submitting. For the purpose of my argument, I need not get into all this, but since the lordship is
Once it is declared as ultra-virus inhibition, all that is to be said is, in view of the provision B, it is struck down, that's all.
it is declared as invalid. It doesn't become void. Lordship will kindly see what Mr. Deshpande points out. Void is absolute, whereas invalidity is relative, invalid to the extent of inconsistency. So, to answer your Lordship's question, if Subramanian Swami strikes down 6A, it need not necessarily become void ab initio. It will depend on the nature.
It's different. Therefore, I say it's a different thing. What you are saying is that, as I understand, subject to correction, the law no more exists on the statute book once it is struck down. Once it is struck down, it doesn't exist on the statute. Now, you may say it is omitted, it's not repealed, any of those provisions. But it doesn't exist on the statute book. Once it is omitted, it doesn't exist on the statute book. Now, there may be scenarios, to that limited extent we said, there may be scenarios where courts should proceed further. It may analyze what is the consequences of declaration in that law, that if it is not to operate, let us say, from day one, are there some consequences which need protection? Correct? Yes. To that limited, that's the reasoning which prevails. Sometimes the reasoning prevails that it should be prospective in effect. Why do you do it? Because prospective overruling is an accepted phenomenon. But you may not make it prospective, but yet there may be some nuances of it which the court can take into. The difficulty is how do we say what will happen in each scenario? All we can say is there are nuances which may arise, and the court should be, let me say, cognizant of the scenario.
Or pass consequential directions
And not necessary in all cases. If required, they may pass certain consequential directions. Only that much will arise. So it's normally the law doesn't exist after it is struck down. But there may be scenarios in which there may be prospective overruling. Similarly, there may be scenarios where the consequences may be taken care of. That's all.
No, I only was entering because when I did this research, I only wanted that this word will fill more.
These are physiologies. Ultimately, you are playing with the English language in a sense. That's all that is happening.
But each word has got a dangerous connotation.
So it can have many connotations.
Nullity. So
Then the interpretation, what does nullity mean? So these are interplay. The point is the law is, in a simple way, I would say the law is not on the statute book, whether it's omitted or anything. But since it held force of law for some time, if there are some consequential directions to be passed, the court will pass.
but one small even what you lordship said, I would only submit to lordship, declare the law to unconstitutional. It is not obligated to do it. It exists, but it is inoperative, it is ineffective. It's provision in the statute, like for example, say the National Company Tribunal, it is there in the Companies Act amended in 2002. Lordship was pleased to they strike it out. The provisions are still there, but they can't be given effect anymore.
They have some chemical. How is the provision still there after it is held to be invalid?
No, but please,
If the statute also, if you print print the act, will you print that provision? No.
Yes.
No.
No, very true. In fact, there is
All that will be written will be omitted.
No.
by this thing. Or there can be different kind. Or at the base of it, you will normally below that line, you will say this is how the provision stood at that particular
Exactly.
time.
No. What I'm submitting to your lordship is I get the authorities also on this point. If your lordship declares, say, section 42 of the Income Tax Act and the Constitution, it is not obliterated. It will continue to be there, but it will be ineffective because to remove 42 from the statute book is a legislative act, and that has been decided by our Supreme Court itself. Because lordship see, for example, 368, please see our Constitution. Lordship
So what you are saying is that
omission and repeal is a legislative act.
at the base it will be said struck down as
Yes. But it will not be removed from the statute. Because that's the legislative act, and that's what many authorities also say, so that the effect of striking on the law, it doesn't mean, because right from Kishore they say, striking on law, a judicial act does not alter or amend the law, it only makes it inoperative. Your lordship declares it to be void. Because under the power of judicial review, or lordship under 226 or 32, lordship can say this is ultra virus 14, ultra virus 16, ultra virus 19. But lordship is 368.
That's why that Pravati Vora case deal.
What's interesting, 368 of the Constitution.
yes.
Yes. Now, my lord, what's interesting, 368, 4 and 5. Please see that 3 and 4 and 5. No amendment of this Constitution, including provisions of Part 3, made or purporting to have been under this article, whether before or after the commencement of Section 55 of the Constitution, shall be called in question in any court on any ground. Then please see 5 for removal order hereby declare that there shall be no limitation whatever on the constitutional power of Parliament to amend by way of additional regulation to be under this Constitution. This is a footnote. My book says footnote 8. I don't know what lordship note says. Inserted by Constitution 42nd Amendment, clauses 4 and 5, which is inserted by Section 45 of the 55 of the 40th Amendment, have been declared invalid by Supreme Court.
That will it be same because Constitution being a different, will it be same for the Act also?
Same, it will be in the Act. It will be just known as held to be inoperative. Because what the authority says, once Parliament frames an Act of say 100 sections, the lordship says strike down 6 of them. That will not have the effect of obligating them. They will be inoperative, it will be like dead for all practical purposes. Yes. So particularly in the book, when they bring the Act again, it will be there with the qualified.
No.
So, I mean, it's on this, when you declare because when all these cases were struck down, this concept of the theory of the second act was not there. What happens to the, because lordship was under our Constitution, there is a presumption of constitutionality. If the act is declared to be unconstitutional, it continues to be valid. Now, when it becomes invalid, then lordship has to qualify, because the lordship rightly put it in all cases you can't say that the acts are saved. In all cases you can't say that acts are struck down. So what has to be done is my question. Now, in the case of 6A, what is the case of the law? Now, lordship just come, I think, the theory of second act, if the lordship wants to bring it into our jurisprudence. Because inevitably, between the time of enactment and striking down, it is going to be living for some time, so to speak. Act is going to be effective. Till your lordship declares it to be inoperational or invalid. If a lordship kindly comes to the theory of second act, please come to. I'll straight away take a lordship to the book by Wade.
Mr. Datar, subject to correction, is it correct that this theory of second actor
Yes.
has been invoked only in cases where administrative action is held to be
Yes,
valid?
because in England there is no analogous concept. Now the only thing is, there it's an administrative law, they can strike down a particular thing as invalid. An administrative order can be struck down, like subordinate legislation. Today, your lordship can strike down a primary legislation. I'm not going to constitutional basic structure, I'm just stopping at the level of parliamentary legislation. Now, in a situation where if there is a gap of say 7-8 years between the act coming into force and the act getting struck down, how far will this theory of nullity or effect apply? So there is it not necessary to bring in the concept, because lordship may say that depending on the facts and each circumstances, this will be a valid factor to be taken note of the case when it is striking down the law or giving constitutional effect to the law. Suppose the law today was enforced for 10.5 years. Now just in my note, just come to the written submissions. Page 6, just come to a submission to the second act, why it becomes necessary. Last page, no?
Yes.
Prior approval for senior protection from 1969. The need for prior approval was initially contained in the Sickle Directive, which was in force from 1969 to 17/12/1997. After the decision of Vineet, the immunity was once again introduced by an ordinance from 25/8 to 27/10/1988. 6A was then enacted with effect from 11/9/2003, was implemented for 10.5 years till 5/5/2014, the date on which to declare unconstitutional by the Honorable Court. Thereafter, Section 17A has been added to the Prevention of Corruption Act with effect from 26/7/2018. Such immunity, that is prior approval, was deemed necessary to ensure proper administrative function of various officials. The continuous immunity further supports the need not to make the 214 judgment prospective in its operation. The reference may also be made to the recent judgment of the PMLA. In the PMLA, I don't want to cite it because it's subject to review. What PMLA case says is that the section 45, which was held to be invalid, condition of bail, that by an amendment has again been brought into force. So they say that when the new section is again brought into force, it is as if it has effect all the time. Now there is a different context here. What it says, from 16 you got immunity. Therefore, these changes are really clarificatory in nature. Right from the beginning, they want to give immunity. What they have done in 17A, this classification of joint secretary have all been removed. All the public servants get the protection. So the so-called discrimination which the court was found to be an infirmity violative of Part 3 has been removed. Now again, when you in 2014, except the small gap, when always they got the protection. And that also is a bearing on 21, because this immunity was a protection given to public servants from day one. And that immunity deserves protection under 20. So that has an impact on 20. And as far as 14 is concerned, if you say joint secretary, they said, all right, we thought that we will give it for people who are making decisions. But now we'll give everybody. So what is the LCM? Public officials will be protected. You can't say they will proceed against them, go to a police station and file an FIR and proceed against them. That's not enough. So now let's come to the theory of second actor. Why I'm submitting it? This is very important page 361. The passage from Wade starts at page 359. Now, Lordship should kindly see. Please see page 361, the famous passage from Lord Radcliffe, which we Lordship has seen a number of times. The first of these, an invalid act may not appear to be invalid, and persons will act on the assumption. We are reading page 360 in the middle.
Yeah.
In a well-known passage, Lord Radcliffe said, an order, even if not made in good faith, is still an act capable of legal consequences. It bears no brand of invalidity upon its forehead, unless the necessary proceedings are taken at law to establish the cause of invalidity and to get it quashed or otherwise upset. It will remain as effective for its ostensible purpose as the most impeccable of orders. So, I would extend it as Justice spoke asked, what about English law? I'm saying Indian law, take it to the parliamentary law. Now, see, today we are in this tribunals matter. Lordship has struck down the bench headed by Sanjiv struck down the provision saying it's not following Roger Matthew. Even after judgment, the same law is reenacted, which is again subject matter of challenge. Now your Lordship strikes it down again. What happens to all those people who have been recruited and appointed as members of tribunal? Your Lordship can say that if you are going to make a law identical to the law struck down by the Supreme Court, will give no protection. You're doing it in the teeth of the Supreme Court judgment. Supreme Court judgment says you can't do ABC. In the law, you put I will do ABC. Then it's up to your Lordship to say no, I will not do protection to this officer. It could also happen that some law is challenged, and after 4 years, the people have been appointed. Lordship will say you're striking now, but people who have been recruited will not be disturbed. So this is what the point I'm making. Now, Lordship will kindly see the final point I wanted to make here. Lordship now comes to 2-3. Yes, Lordship will also read the theory of second act which I mentioned already, which is at 364. The theory of second act. An important step, 364.
Yes.
It's up to your Lordship to decide whether we should import it, because I am suggesting it's an important factor if your Lordship while striking down. Important step in developing a principled and practical approach to these conundrums. Now, the conundrum is, it is void in law, but actions have been taken. So, what to do? Has been the development of the theory of the second actor. This theory, which has attracted significant judicial support, seeks to explain how an unlawful and void administrative act may nonetheless have legal effect. It is built on the perception that while unlawful acts, the first acts do not exist in law, they clearly exist in fact. Those unaware of their invalidity, second actors, may take decisions that act on the assumption that these first acts are valid. When this happens, the crucial question is whether these latter or second acts are valid. The theory of the second actor holds that the validity of these second acts does not depend on any presumption of validity or judicial exercise of a discretion to refuse a remedy to an applicant in particular proceedings. It depends on the legal powers of the second act. Did the second act have power to act even though the first act was invalid? Thus, in a case discussed above, etc. So the point is, so long as the first act is valid, the second actor, who is the person implementing the law, what is the protection he gets? Now, Lord, last 2-3 judgments I just quote. Please come to where this court has, the Lordship comes to the index. I quoted from serial number 21, 22, 23, 24, where the courts have passed struck down a law but then protected the act done in the mean. So,
It can always be done.
yes. No, so just to say, that when you declare a law, it doesn't mean it's a validity gone forever and ever. No. You can always, because the point is, what I'm trying to say in Jagannath's case is, if you see it's still gone validity, because it's not just a matter of semantics of words, each word has got a connotation. So the proper physiology should be, since the Lordship is sitting in the right judgment, and the court declares an act to be invalid, it is not still gone, it is not dead, it's not validity. It is invalid or ineffective, it is inoperative, that's all. And till it is declared ineffective, whatever has been done may have consequences which have to be reckoned with. It can't simply be wiped off with a plot and say, all of this is gone completely. Now, Lordship will just come to go on real estate. Just 2 cases I'll point out.
On what property?
Yes, who say that where they and yet they said that
Mr. Datar, that is receptive to action. You can always do so.
yes, I will give the para numbers. Lordship will see. I won't trouble Lordship. Now, finally, not my subject is. Yes, yes. So if your Lordship has the time, Lord, I just put this 348. I included this very famous article which has been cited in number of books. This there was a festival in honor of Sir William Wade, and there is a book published called The Golden Memoir and the Crooked
And
Clock.
by that Porsit.
Post-it. page 348, where for the first time they introduced the concept of they call it nullity. The law is invalid. It is invalid in law, but it is valid in fact. So it leads to some kind of conundrum, and this was discussed to me. Yes, because for example, physics.
Creates more conundrum.
Conundrum. Even more conundrums.
Ultimately, in fact, in the Lord Macmillan's biography book, they say that every case which comes to court is really a failure of the law. In that sense, because the law is very clear, there will be no case. That's another extreme view they take. So, my Lord, I'll just sum up my submission by submitting not this reference, which is taken up. Yes. No, I'll just sum up my submission by saying that 6A, in a sense, is not just a mere procedural part, but is also substantive protection to the officer. It is entitled to the protection of 21. I would humbly request your Lordship to see the question raised by the Supreme Court of Transmission Corporation, where they said that, look, don't read 21 just in a straight jacket way. Even the immunities protections are also considered as part and parcel of it. I would further submit that 20 clause 1 should be read in harmony with 21, article 21. And the judgment in that Prabhudaya's case, which is Nath's case, that the history of liberty is a history of procedure. And procedure is a bastion for, if you lordship take that to your mind, it further strengthens the point that 6A is really a protection. It's a bastion for all civil servants from harassment, etc. And that protection was given, was a protection entitled to the protection of 21, and the judgment cannot take away that protection. That on the other point I'm submitting is Article 14, and now I just address this point which is spoke also related to Khanna related to 31B. 31B doesn't make the law declared to be invalid. What it simply says is, even if a law is declared to be invalid, once you put it in the 9th schedule, it is deemed to be valid. The argument of the lawyers was that if it is stillborn, if you accept this theory of stillborn, etc., as per the administrative judgments, then where is the question of putting in the 9th schedule? There in paragraph 22, they say, please don't follow American case law. They expressly don't, in so many words, they said, we will not get into the stillborn issue at all. There is a law that has been struck down. It is still there, it is inoperative. It is moribund, it is comatose. You put it into the 9th schedule, there which was inoperative, will acquire like proprio vigore is what they say in Jagannath says. So, to summarize the history of law from where I'm based, my humble submission would be a declaration of unconstitutionality doesn't make the law blindly dead, stillborn, those restrictions are no longer good law after Jagannath. We should use the word inoperative, ineffectual. And secondly, thirdly, there is no difference between striking a law for competence and this. Both have the same effect, it becomes unconstitutional. And my humble submission is, if the Lordship so feels, when a court declares a law to be unconstitutional, the court must also consider various factors which is quoted in the Goan case. How long was the law in existence? Who are the people affected? What is the public interest in the law? So, the Lordship did not really let it go into those passages. Where they say all these factors must be kept in mind when you declare a law to be valid and consequential directions can be taken. And if the Lordship so believes with for the guidance of other high courts and other courts, all of us also, declaration of unconstitutionality should normally consider whether the judgment should be, whether the law should be dead from the beginning itself, or it should protect what acts have been done in the interim. That's all I want.
Thank you.
So not a topic on which I was tending to address, but since it has.
You are for whom?
I'm sorry,
You are appearing for whom, Mr.
it's the same matter, okay, Mr. Bali. I was actually going to, we have divided the legal issue, but I just spent 3 minutes and not more.
Okay.
Because I've not got any judgment, but I just thought I'll make a few broad submissions.
I was discussing within the
Yeah,
concept of
it's
2021.
and so much. Just a few moments on the request. The Lordship would see is that so far as the issue is concerned, the history of the law has been that public servants as a class, have been recognized as the class, have always received protection in the realm of criminal law. The protection in many ways is at three levels. One is at the stage of initiation of investigation. One is the conduct of the investigation by a superior officer, and then at the sanction level. So the underlying principle going back from 1800s, because the original provision for sanction was in the 1898 code, in fact in the 1872 code also. So what your Lordship says is that the public servants as a class need a certain protection for the reason that have already been articulated in a series of judgments. Now the issue that came up in this matter was that whilst this particular protection was necessary for the public servants in the form of initiation of a prosecution, an issue of discrimination arose in the context of 6A. Petitioner, you've already seen about the question of legislative competence. And in the context of 6A, there was not that the court intended to take away the fundamental protection that a provision such as 6A intended to give to the public servant, but it noticed a discrimination within the section that it protected only public servants of a certain seniority and did not protect the others. So there was an Article 21 protection to ensure protection for initiation of investigations against a public servant. When this was brought to the notice, all that your lordships have noticed is that it was struck down on the ground of discrimination, but not on the ground that this particular provision is not a provision that should be made available to a public servant at all. That protection was necessary, and that's held by a series of judgments of the court. So what your lordships have for your lordships today is a technical provision, argument and a ground on which 6A was struck down, but not on the substantive provisions of rights under Article 21. So because of this conundrum that your lordships now see, because in Swami's case, they've said that on the ground of discrimination, 6A has been struck down. What happens to the larger protection that the legislature always intended to provide for public servants as a class? Therefore, when your lordship sees that all the types of protection at every level, and your lordships have upheld the protections for public servants, then should there not be a clarification that in relation to this particular aspect of the matter, where the protection is still necessary, and it has been reintroduced in 17A, that a need arises for a clarification. It's in that context, your lordship will just see paras 34 and 35 will go on. I think my learned friend was going to read it, but may I just point out, because when your lordships then deal with a situation of this type, where there is a 21 right, but for certain reasons, the court feels there's a need to strike it down. But there's a larger protection that's necessary. That's the protection that your lordships are referring to. And how do you deal with this conundrum that is now before your lordships? So your lordship will just see page 410, as your lordships have said, paragraphs 34 and 35. What are the considerations when your lordships would render a judgment in a situation like this? And I'm not wanting to expand the scope to all cases. I think let's limit it to.
Your argument makes me think, really speaking, whether this nature of protection given to a civil servant is mainly a statutory protection or protection under Article 21.
In fact, a lot of these are 21 protections.
No, may not be. If it is 21 protection, it will apply across to all citizens.
As a class apart.
As a class apart. And that protection is inbuilt because investigation either by CBI or by the police is always considered to be and required to be independent, fair and transparent.
Right.
So that protection is the protection given under Article 21, which is applies across. This is basically a statutory protection given for a good reason. Given for a good reason. And the protection which is given in 6A is under the Delhi Special Police Establishment. It doesn't apply to investigation under the IPC or under the PC Act, whereas 17A is the protection now given under the PC Act.
But 6A,
And really speaking, where the cases of problem are arising, subject to what they say, would be the cases, what is the real effect of clause 2 or subsection 2, section 6A, because most of the cases, they won't take the permission for investigation, etc., except in cases of subsection 2. Really, the dispute in most of the cases will be whether you fall under 2 or 1. It's in cases of where the department says you fall under 2, but the officer, public servant says, no, I fall under 1, that problem arises. And then that technical difficulty, because there is no approval of the central government, then the case is fought. That's the real, in practical terms, that's the real problem. Because otherwise they would, in most cases, they will not proceed. Being whether it's CBI or the state or the police, they will never proceed. But they are getting into difficulty when it comes to whether you fall under 1 or subsection 2.
What your lordship is 17 expanded the scope. It actually widened the scope from 6A. So while 6A was originally in the ESP, when they introduced it back in the Prevention of Corruption Act, they expanded it because all persons who can investigate a case under the Corruption Act are now subject to 17A.
Because really speaking, why should there be a distinction between a public servant and otherwise?
That's
Because
true.
all investigations are done by independent and specialized, where the state which is a representative of the person, that is the police or the CBI or any other authority, is independent. They're supposed to be fair and independent. Absolutely.
Your lordship, that's a larger question, but your lordship will see that history has been always to categorize public servants as a separate class and provide protection. There have been a series of challenges to various levels of these protective provisions, and your lordship have repelled the challenge.
That's a administrative principle actually, that by the very nature of job they perform,
That's right.
there may be scenarios where there may be people who they may face something for doing their jobs which they should not.
That's right. It's essentially to save them from the harassment. That's where therefore constitutional challenges have been repelled to 197, 195. The whole series of provisions have been always repelled, saying that they're the class part. What happened in 6A was, within 6A, the protection was only to a senior servant and not to a junior. And that was the discrimination that was noticed when 6A was struck aside. It was not for the purpose of not giving the protection to a public servant. And it is in that context the question to arise that whilst your lordship has struck down 6A, should some clarification be issued, and therefore while dealing with it, 34 and 35 indicates that when your lordship are dealing with a provision like this, which is a protection, it's a fundamental protection to a public servant. That protection has been reintroduced in a wider form.
That in the beginning we said.
That your lordship has said. So therefore the question really was that how we deal with it. So therefore your lordship has said 34 and 35.
Thank you.
And then, and on 2021, I just had a slightly different perspective on 20, where I might say that 20 might be limited in its application to a conviction. And that last bit about immunity might extend itself to immunity from prosecution, which may be there under various provisions, either under the Constitution or under statute. So if there's an immunity from prosecution, then can there be an ex post law which takes away that immunity? So there could have been the issue of what is the meaning of immunity within the meaning of which is the term used in transcript. 20 might be only
Yes, now, sister, you will begin first, or?
No, I'm told, he wants to say something. But I
I don't know what second stage.
have no difficulty. He said he wants to say something. I may begin tomorrow.
No, who you are appearing, you will be addressing on behalf of
The central government, Union of India,
Mr. Raju.
not CBI. But substantially, we will not repeat anything. Our submissions would be over.
We heard Mr. Kishore, now what further? Mr. Kishore, what do you have to add further?
No, Mr. Datar has, the Learned Council has raised certain issues.
Actually, we have a scenario where all of you are on the same side practically.
So I wanted to offer a brief comment.
For a change, even the government is not largely on another side.
No, I essentially assist your lordship, not without
No,
any.
I'm just saying.
Yes, sir, the lordships are right.
Of a counterpoint, there is no really counterpoint to.
Correct.
That's fine. I don't think anything. Yes, you may begin.
Can I begin tomorrow? That's all I'm saying. For 10 minutes, why?
How much time will you take?
I don't think more than a session, my lord. Maybe a few minutes more, my lord, thereafter. But it would be over tomorrow. I don't see any.
No, there will be difference between whether to keep matters for the half session or not.
I
thought you will not take more than half an hour, 45 minutes. Everything is said now. And you will be more or less, in assisting the court, will again be drawing on the principle of protecting the civil servants.
No, certainly. I will have to show, my lord, the distinction and, my lord, the myth which is created now, so kind of a protection is more rigorous protection under 17A. Another premise was
What an issue before us, really?
that has to, my lord.
Before us. The only issue before us is that
Between 14 and 17, what will be the position? And, my lord, pre-14.
that
Pre-14, sorry.
there was a protection granted. That protection was struck down as discriminatory.
Not only on that ground, but we'll show that.
Legislature in its wisdom brings it back in a slightly different form. Having brought it back, what would be the scenario for the intermittent period? That's all that is there.
That's correct.
Okay.
But, my lord, I would request your lordship, my lord, not to have any sitting in the second half, my lord, so that we do not have that mental pressure of
No.
finish.
Certainly we want the mental pressure and all of you to
Your lordship, my lord, your lordship may not have.
See, look at this way. We had scheduled 3 sessions for it, 3-hour session. I will abide by my 3-hour session. You must finish in the first half. Yes. Thank you.
Lord, your lordship would treat that provision to be mandatory and not directory. On the lighter side, at the end of
Everything is in a particular way, but we all see. I keep saying only it's a mutual thing. We'll have to respect timing, all of us.
certainly. That doubtless.
To conclude matters, there is another set of matters, the 3 judges benches which are waiting. So fortunately,
No, I am not for a second saying that we want to delay them.
I'm sure you will not prolong it more than necessary. And I'm sure with your ability, you will be able to address this in half a second. This recorded that. I didn't part. Go on.
Obliged to your lordship.
Okay.